Good evening, good morning, good afternoon. Like, subscribe, welcome. Not legal advice. Uh, Tonight's supposed joke. What's the difference between ignorance and apathy? I don't know, and I don't care. Thanks again for that wonderful joke from little Billy, little Bruce T out there. Thank you very much. And kind of tonight, I wanted to talk a little bit about the result in the Tesla shoe case. It's actually shoe, HSU versus Tesla. And it was a accident for personal injuries relating to an accident that occurred in 2019. Ms. or Mrs. Shu had a Model S, and she had an accident in which I guess her car swerved and hit a curve, and I guess it was going very quickly. And she hit the curb, her airbags deployed, and as a result, it must have been quite a collision. The airbag and the collision broke her jaw. So that had to be quite a collision. So in 2020, so the accident occurred in 2019. In 2020, she or her lawyers, who unfortunately are probably not having a very good evening tonight, um, sued Tesla and I believe also Mobileye. So Mobileye was a company that was working with Tesla uh, years back, obviously in the autonomy space, and they still are. They eventually became a property of Intel, and I think either in 2022 or this year, they spun off in an IPO, and so they exist. So in this particular case, Shu versus Tesla, Mobileye was also a defendant. And I guess just to reference that, you can have a case where there's multiple defendants. And sometimes you won't know what the defendants' names are when you start. And you identify them in that respect as does. And you'll look at oftentimes at a complaint. If you look at the first page, it'll have all the names and it'll say does 1 through 100 or something along those lines. And what that's for is as the case goes on, you may discover parties that should be defendants. And when you discover their names, you substitute those numbers. So you'd say, I've discovered now Doe 1 is Mr. X. And that's how you would add them into the case. But in this case, I don't know if Mobileye was a defendant or a nominal defendant or they were a major defendant. But they were obviously involved in Autopilot. So again, the case was filed in 2020, and trial was just completed April of 2023. So that took 3 years. So that is somewhat a example of the speed of our legal system. Now, as I indicated, the case was tried in Glendale, California, before a 12-person civil jury. And in California, in a state court, in a civil action, the verdict does not have to be unanimous. But I think in this case it was. It's interesting to note, though, and I don't know how this plays into this, but it's interesting to note that Glendale is a somewhat conservative community in LA. I don't know their position on Tesla, but I can't imagine they're super Elon fans. But they're also not fans of big plaintiffs awards. So it'll be interesting to see how that played out. And that's interesting because this, in fact, was perceived in part as a test case for all those cases that are pending involving autopilot or full self driving and accidents. Most of them involve claims of defects and, let's say, questions about warnings. But what's interesting about this case, and I'm going to call it the Shu case, Shu versus Tesla, it's like the Diaz case. And I did a video on the Diaz case. So the Diaz case was that claim by a former Tesla employee that had been discriminated against at Fremont. He got an award of $115 million approximately. That was reduced. He had an opportunity to accept $15 million. he elected to go forward. He got an award of $3 million. That's perceived as being an inhibiting factor for plaintiffs' lawyers to go forward on those types of cases in the future, because that was in San Francisco. The award was reduced, and it will be a disincentive. So this case, the shoe case involving full self-driving, autopilot, etc., will be also, depending on how it turns out, because I haven't given you that yet, but depending on how it turns out, it'll serve either to encourage or discourage these type of cases, and it may serve as some indirect precedent against cases involving full self-driving. And just to explain what the precedent would be, just because a trial court rules in a particular way doesn't have precedential value. It has to go up on appeal. It has to become a citable appellate decision. Once it's citable as an appellate decision, then when I'm briefing something in a case, I can cite it. If it's just a trial court issuing a ruling, it doesn't have that value. Anyway, Xu was, after the case, was tearful following the conclusion. She claimed that there were both defects in the autopilot system and the airbag system. She sought $3 million in damages. And again, she broke her jaw as a result of the accident. So if she had received $3 million, if that was the result of the trial, there would be some reduction for medical liens, for medical treatment she had incurred, which would have been part of the case. And then the attorney would have gotten 33 to 40% of the award. And instead, he got bupkis. And look that word up if you don't know. Tesla denied any defect for the 2019 accident and indicated it had offered numerous warnings that Tesla should not be used in city streets. Tesla had its head autopilot engineer testify during the 3-week trial. The jury found that autopilot did not fail, that the airbag system functioned properly, that Tesla had given adequate warnings, and that the accident, probably like most accidents, was due to driver inattention, besides possible misuse by the driver in terms of where she used it. Tesla was clear that this was not full self-driving. Although the writers, it's interesting, when I was reviewing this, preparing the video, I read a bunch of articles, and the writers seem to confuse autopilot with full self-driving, which is interesting because they're doing a story on it. But this also is back in 2019, so any and all those systems have substantially improved. There's several comments by jurors that there were plenty of warnings, not financial advice, but it would appear that both the Diaz ruling and this particular ruling are bullish because they will discourage, to some degree, they will discourage future lawsuits in these areas and probably will encourage lower verdicts. So for all, I think that's all good for Tesla. It also kind of will weed out claims that are really bogus claims. So I think it's a really good ruling for Tesla in these two areas. And, it's possible it could be appealed, but we don't know. But beyond that, the ruling was that Tesla's system worked as promised and had adequately warned. The thing I found very funny was the jury forewoman basically was praising the actions of Tesla, and she said she wished that her car had those features that was referenced in the trial. So all in all, it was a bad day for Dan O'Dowd. And if you don't know who he is, look him up. But he's crying tonight. Have a good night. Tesla wins this one.